Change it or obey it. Why the Constitution is the solution. Today in our nation, we have clearly strayed from the original intent of the Founding Fathers. I have a couple quotes I want to illustrate this with. First of all, with Thomas Jefferson. He says, "Congress has not unlimited powers, but only those specifically enumerated." That would be specifically enumerated in the Constitution itself. Another perspective from James Madison, Federalist 45, he tells us the powers delegated by the proposed Constitution to the federal government are vague, right? No, he says they are few and defined. Those which are to remain in the state governments are numerous and indefinite. Now that might be a little vague, the powers that could remain to the states. But which one of those sounds bigger? Who's supposed to have more power, the few and defined federal or the many numerous and indefinite powers of the state governments? Obviously, the states were supposed to retain the majority of powers, according to James Madison, the father of the Constitution, as history calls him. Today, we've clearly reversed that, where the federal government is much bigger than they were ever intended to be. In fact, I often declare that the federal government we have today bears little resemblance to the federal government as defined by the Constitution. But further still, here we have an article from the Washington Post entitled "The Rise of the Fourth Branch of Government." Now, as I recall in my high school history classes and learning about U.S. government, there were only 3 branches of the federal government, right? Well, we have a new branch of the federal government they're talking about that has come to be. What they're referring to is the federal regulatory agencies, things like OSHA and the TSA and so on. In this article, they point out that one study found in 2007, Congress had enacted 138 new public laws, while federal agencies finalized 2,926 new rules. Every one of those rules carried with them the force of law. They are effectively new laws. The federal agencies are far outpacing Congress in the creation of those laws. Now, we're told in Article 1, Section 1, Clause 1 of the U.S. Constitution that all lawmaking power is given to Congress, not to the President, not to the Supreme Court, and not to the regulatory agencies. But today, the situation we have, these federal agencies are empowered to write their own rules, to enforce them, and to judge of their infraction. We're effectively rolling all 3 branches of government into one: the legislative, creating law, executive branch, enforcing, and the judiciary, judging of their infraction. On this concept, James Madison warned, the accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of OSHA. Okay, he didn't say OSHA. OSHA didn't exist then, but that is tyranny. And that is what OSHA and many of the other federal agencies do today. If, for example, your company is being investigated for OSHA violations, and they charge you with an OSHA violation, they're not only writing the rules, they're now enforcing them. And if you want to appeal their ruling against your company, you'll be appealing that before a judge of an OSHA court. They truly are all 3 branches of government rolled into one, far beyond anything the Founding Fathers envisioned when they created the Constitution. The question now comes up is, what do we do about it? Today we see a number of organizations that are pushing for what's called an Article 5 convention to make changes or amendments to the Constitution, which they propose this was the way to rein in the federal government. So in today's presentation, we'll be exploring some of these claims. In order for this to happen, first, there's marketing claims of convention promoters. The way this works, the convention promoters are going around to our state legislatures, because they're the ones that would decide whether or not we will have an Article 5 convention. It takes 34 states' legislatures applying for a convention, at which point then Congress calls for a convention for proposing amendments to this Constitution. As they're making various claims to our state legislators, I found that a lot of their claims are not backed by history or fact, and we need to expose some of those. In Part 2, we'll cover some of the proposed amendments that are being discussed and compare them to what we already have in the Constitution. And then in part 3, we'll explore true constitutional solutions according to the words of the Founding Fathers themselves. So part 1, marketing claims of convention promoters. To begin with this, I want to play with you a little bit with a brain teaser. Billy's mother has 3 children. And the 3 children, first one's name is Penny. The second one's name is Nicole. And the third one is what? Quarter? No. George? No. I have all kinds of different suggestions that come up here. This should be obvious, but it generally isn't. Listen to me again carefully. Billy's mother has 3 children. The first one's name is Penny. Second one is Nicole, and the third one is... Now I'll do it slowly. Billy's mother. Whose mother? Billy's mother has 3 children. So who's Billy? One of the 3 children. So if there's one named Penny, the next one's Nicole, the third one is Billy, right? That should be immediately obvious, except for one thing. What is the purpose of these coins? They serve as a distraction. They're intentionally there to deceive you, to help you not see the obvious answer. This is a common marketing tactic to get you to focus on what we want you to focus on rather than something that might not persuade you to believe the way we want you to. So this is a tactic that we're seeing being used with our state legislators. I'll demonstrate. We'll use the penny to represent the first one. They'll tell our state legislators this Article 5 convention was put in the Constitution for such a time as this, for the very purpose of reining in an out-of-control government that refuses to obey the Constitution. That's the false claim, as we'll demonstrate momentarily. The second claim, they'll tell you that this is the only solution big enough to solve the problem. Again, false claim. But if you believe both of these, this is a foundation for which they'll put blinders on you now. Once you believe these two things, when someone like myself comes along and says they're misleading you with some of their claims, you're going to cling to, this is what Article 5 Convention is for, and it's the only hope. And if I come along and I'm taking away from you what you believe is the only hope for our nation, you have a tendency to resist and fight against it. And hopefully we can take off those blinders for a moment and give an honest assessment of what is Article 5 really for, what are solutions that the Founding Fathers really recommended for such a time as this, when the federal government is clearly overstepping their bounds. There's a third claim that they often make, and this is based on history. There's ever a debate on whether or not historical precedent is a concern here. They'll tell you this Article 5 convention will be totally controlled by the states, and don't worry about any historical precedent, such as the 1787 convention where our current Constitution was written. They'll tell you that was not a runaway convention. That convention stayed well within their bounds of what they were instructed to do. So we have no concerns. No such conventions have ever exceeded their authority. You get an idea of what some of the concerns that are being raised might be there. So let's examine these. First of all, solutions according to the Founding Fathers. When they talked about using the Article 5 Convention for proposing amendments to the Constitution, here are some of their quotes. Article 5 is for, Alexander Hamilton tells us, for supplying for any defects that may be found in the Constitution. Here's the way to correct those. James Madison tells us Article 5 is for the amendment of errors in the Constitution. Madison also says, should the provisions of the Constitution, as here reviewed, be found not to secure the liberty and happiness and safety of the people, then amendments to the Constitution through Article 5 are appropriate. Washington's farewell address, if in the opinion of the people, the distribution or modification of the constitutional powers be in any particular wrong, let them be corrected in the amendment process as the Constitution designates. They're all talking about using the amendment process, but do you notice the common theme here? In every case, they're saying if there's an error or a flaw in the Constitution that is causing problems, then of course we correct and amend the Constitution. Now, what did they say we are supposed to do in cases where the federal government is overstepping constitutional bounds? It's not a constitutional flaw, it's that they're simply not following it. There are many places we can point to where the Founding Fathers talked about what to do in those cases. One, for example, is Federalist 46. Madison says in Federalist 46, the means of opposition to it, to overstepping constitutional bounds, are powerful and at hand. He lists many. I'll show just a few. The first one, he says, is the disquietude of the people is a great tool. I love that word, disquietude. I'm going to try to use it more in my own vocabulary. What does disquietude mean? That really means the people are getting upset. The people are unhappy with your performance in office. And if, as an elected official, too many of your constituents are upset with the way you're working in office, the way you're upholding your oath, you're not likely to be reelected. He referred to this as a powerful tool the people have, but it's not the only tool by any means. On the state level, in particular, he talks about the refusal to cooperate with the officers of the union, that they won't help in the implementation of unconstitutional actions of the federal government. He also said state legislators have the power to create legislative devices to present obstructions, which the federal government would hardly be willing to encounter. They can help block unconstitutional actions, as well as not complying and not helping with them. These are all powerful tools. Notice what's absent from this list and all others. When the Founding Fathers talk about solutions to cases of overstepping constitutional bounds, they never talk about Article 5 as a solution there. In fact, historically, take for example, in 1798, when Congress passed the Alien and Sedition Acts, these were, among other things, making it illegal to speak against what the President and Congress are doing. Clear violation of the First Amendment. James Madison and Thomas Jefferson were very concerned and upset about this unconstitutional law that had just passed through Congress. Did they turn to Article 5 as the remedy? No, they did not. What did they do? They wrote the Kentucky and Virginia resolutions of 1798, which were talking about nullification. The states have the power to stand up and say, no, we will not help in implementing this law. We will refuse to cooperate with the officers of the Union, creating legislative devices to present obstructions to it as well. So both in their words as well in their actions, we see that in cases of overstepping constitutional bounds, they did not turn to Article 5. This is a myth that has been created today by those that are presenting this Article 5 convention as the solution. Now, recently in 1989, the Nevada State Legislative Assembly had an application for applying for an Article 5 convention, which they were submitting a rescission of. So this is the U.S. Congressional Record saying, we want to take back our application for this convention. Why? Effectively, they said we were tricked into applying for it. Here's their exact wording. This application was induced by fraud. That's a powerful word. They called it fraud. The people that were presenting to us this plan of you've got to apply for an Article 5 convention misled us. And they list some of the things they felt they were misled on, some of the points, some of the claims they made. I want to examine some of these claims that are being made today that are very misleading. So one of the claims that I talked about was we don't need to worry about the precedent set by 1787. This is one of the most everlasting debates between those that are promoting a convention and those that are opposing it. What really happened in 1787? Here's one of their claims. The Constitutional Convention of 1787 was not called under the Articles of Confederation. The Articles made no provisions for such a convention. And his conclusion he draws from that is, therefore it could do anything which the states allowed it to do, up to and including choosing a method of ratification for its own proposals. So here's the claim. The 1787 convention could do anything they wanted to. They were free to do whatever they felt was necessary as long as the states said so. This comes from Robert Kelly, staff counsel for Convention of States. The co-founder of Convention of States, Mark Meckler, in a recent debate, December of 2016, he makes the claim, the greatest authority on the subject is Madison, who was at the 1787 convention himself and wrote in Federalist 40, if we want to know what the authority of the framers actually was, look to their commissions. You allege the 1787 convention ran away, and I would ask you the question, and it's a critical question, have you read those commissions? This is one of those times I'm watching this debate, and I wished I could jump through my computer screen and sit next to one of his opponents and answer this question for him. What he's suggesting is, and he's exactly right, Madison said, look to their commissions to see what their authority was. And he's then implying the 1787 convention didn't run away, they followed their commissions. I have read those commissions. I'm a little analytical. I put together a whole spreadsheet and itemized everything that every one of those commissions say. What are the commissions? These are the instructions from the states to their delegates that attended the 1787 convention, telling them, here's what we want you to do in order to represent us. That was the authority they were given from their states. And as I read through those commissions, that is why I conclude the 1787 convention exceeded their commissions. They overstepped the bounds the states gave them. I'll demonstrate. So first of all, they're talking about the convention not being under the authority of Articles of Confederation. That was our first constitution, the Articles of Confederation. This was the existing constitution, the supreme law of the land, when the 1787 convention happened. They said in this Articles of Confederation, Article 13, any changes to be made to our Constitution must be agreed to in Congress and afterwards confirmed by the legislatures of every state. Keep those two in mind. We're going to see them again and again. Agreed to in Congress, confirmed by the legislatures of every state. So, when the 1787 convention happened, it was first triggered by or called by a convention the previous year. In Annapolis in 1786, 5 states got together to discuss trade problems they were having between the states. And as they tried to resolve the problems, they concluded that the Articles of Confederation is the problem we're facing. We need to call for a convention that proposes changes to the Articles of Confederation. So they submitted what was called the Annapolis Convention Call for the Convention of 1787, where our U.S. Constitution was written. And they concluded by saying whatever they come up with in this convention should be proposed to Congress, and when agreed to by them, and afterwards confirmed by the legislatures of every state, then it becomes part of this Constitution. Does that sound familiar at all? Agreed to by Congress, confirmed by the legislatures, that's what we just showed on the previous slide. That's a direct reference to Article 13 of the Articles of Confederation. That was the existing constitutional requirement, and Annapolis was recognizing that. You're going to have to follow the ratification process as dictated by the existing Constitution. Next, as we start looking to the state commissions, just like was told to us by Mark Meckler on the previous slides, look to their commissions. Let's start looking at those. The first state to issue a commission to their delegates was Virginia. And they said, whatever you come up with in that convention in 1787 will be reported to Congress, and when agreed to by them and confirmed by the several states, will become part of the Constitution. That sounds familiar, doesn't it? Again, referring to, you're going to use the Article 13 ratification process. The next state was Pennsylvania, and they used almost the exact same words. Refer to Article 13 for the ratification process. Every state thereafter, we have Delaware, Georgia, Congress, New York, Massachusetts, South Carolina, Maryland, and New Hampshire, all using very similar wording, referencing that whatever you come up with in this convention must be agreed to by Congress and afterwards confirmed by the legislatures of the states. That in total is 9 states out of the 12 that attended the convention, plus Congress, who gave their stamp of approval on this convention, and the Annapolis Convention that first started. All are referencing what? You're going to have to follow the existing constitutional requirement of ratification. Congress approves it, and all state legislatures approve it. Now, you might remember in history, the 1787 convention, Rhode Island didn't even show up. They were protesting this. But they sent a letter to the convention explaining, here's why we didn't come to the convention, some of our reasoning, but whatever you come up with, even though we're not there, remember, any alterations must be agreed to in Congress and afterwards confirmed by the legislature of every state. So now you have 10 states on record saying you've got to follow the existing constitutional ratification process, and Congress, and the Annapolis Convention, and of course this is the constitutional requirement. Is this a limited convention? This convention was clearly being told you've got to follow this ratification process. Did they do that? No. In fact, at this point we turn to Federalist 40 again, James Madison, who tells us very clearly, it is admitted that the convention have departed from the tenor of their commission. Remember the first quote from Madison? Look to their commissions? We've looked to their commissions, haven't we? They did depart from their commissions, and now Madison's telling us the same thing. They've departed from the tenor of their commissions. Instead of reporting a plan requiring a confirmation of the legislatures of all the states, they've reported a plan which is to be confirmed by the people, not the state legislatures, and to be carried into effect by 9 states only, not 13. They changed who ratifies, and they changed how many would be required for ratification. They greatly lowered the bar. Why? Well, they recognized that this new Constitution was a significant shift of power away from state legislatures. How many state legislators do you know that would willingly surrender a large portion of their power? Not likely, is it? They knew that at this time as well, that this new Constitution would have no chance of ratification by the existing requirement. So they felt it was necessary to violate their commissions and to change the ratification process to an easier, more likely process. Now, as you read through Federalist 40, there's one thing you'll see as a very common theme. I recommend highlight every time that Madison mentions the people in Federalist 40. The majority of them are talking about his plan for appealing to the power of the people themselves. And this is where Madison himself is refuting the claim that what they did was illegal. I'm often given that charge as well. Oh, you must just believe the Constitution was illegally adopted. No, I don't. I side with Madison on this. Madison clearly tells us that the authority that they acted under was not the authority of the states or Congress or the existing Constitution. He says that they appealed to the right of the people to abolish or alter their government, as to them may seem most effective in protecting their safety and happiness. They appealed to the highest authority in the land. Remember, we the people created the states. And through the states, we created the federal government. We the people are the highest authority in the land. And so he went over the heads, as a convention, they went over the heads of the states, Congress, and the Constitution and appealed to the highest power of the people themselves. This is clearly a false claim. The 1787 convention was, according to the commissions from 9 states, plus Rhode Island and everyone else, under the Articles of Confederation. And yet, they ignored that. The precedent this sets is one that the convention promoters cannot escape. That is, that even if a vast majority of states gives instructions to their delegates, like was done in 1787, they can ignore those limits and appeal to the power of the people themselves to alter or abolish our current Constitution. Now, oftentimes when I'm in debates with people on this topic, they can't go anywhere on that history. It's clear, it's solid. So they'll divert to another argument. Oh, well, they can't possibly change the ratification process today, even though they did in 1787. And one of the arguments I have, this one comes from Professor Robert Nadelson, where he tells us the Supreme Court has already ruled that conventions can't change the ratification process. In Hawk versus Smith, 1920, the Supreme Court ruled that no legislature or convention has the authority to change the ratification process. When a law professor cites Supreme Court rulings, do you go home and look them up to see if he's telling you the truth? I would recommend you start doing so. That's what I did. I went home and looked up Hawk versus Smith, and this is the closest language in the entire ruling to what Nadelson said. The language of the article is plain and admits no doubt of its interpretation. It is not the function of conventions or, wait, that doesn't say conventions. What's wrong here? It's not the function of courts or legislative bodies, national or state, to alter the ratification method which the Constitution has fixed. It didn't say conventions, did it? Where did this claim come from? It's a little baffling. Clearly what he's saying, Hawk versus Smith says, it does not say. And whether this is just an inadvertent error or an intentional deception, either way it is false. What do we learn from this? Well, number one, the Supreme Court has not ruled anything about conventions having or not having the power to change the ratification process. If they were, that would actually strike at the foundation of the Constitution itself, wouldn't it? For that is how our Constitution came into being, was a convention changing the ratification process. They have some serious problems with the claims that they're marketing to our state legislators. This one is clearly a distortion of what the Supreme Court has said. Now, what could happen? Here we have a law professor, Sanford Levinson, who wrote a book, Our Undemocratic Constitution, where he thinks we need to change our Constitution to be much more of a democracy, which those who understand the difference between democracy and republic know how dangerous of an idea that is. He says we should have an Article 5 convention to consider the adequacy of the Constitution and, his hope, if thought necessary, draft a new Constitution. And he proposes will be submitted to the electorate for its approval or disapproval by majority vote. What's he suggesting? That at the end of an Article 5 convention, we should change the ratification process and put it out to a simple majority vote of the people themselves to ratify or not these new constitutional changes. That causes some concern to me. I've seen the simple majority vote across our nation vote for a number of things that I think are hostile to our Constitution, our principles of liberty. Conservatives in particular are concerned about if we were to lose the Electoral College and go to a simple majority vote for our president, what that would entail. So there are definitely some concerns here. Now, James Madison had some concerns about calling for an Article 5 convention as well. He wrote a letter to George Turberville in which he tells us, having witnessed the difficulties and dangers experienced by the first convention, the 1787 convention, which assembled under every propitious circumstance, I should tremble for the result of a second convention, meeting in the present temper and under all the disadvantages I have mentioned. In this letter, he is warning against an Article 5 convention. Those that are promoting a convention in order to do some damage control on this have made some very interesting claims. They'll say, oh, he wasn't talking about an Article 5 convention. This letter was written before the Constitution had even been ratified, so he couldn't possibly be talking about Article 5, which was written into the Constitution. Is that true? Simple timeline reveals. Remember, it was only 9 states that they said had to ratify this new Constitution. That happened in June 21st of 1788. In September 13th of 1788, Congress declared our new Constitution to be ratified. James Madison wrote this letter to George Turberville November 2nd, 1788. And so chronologically, clearly, Madison already knew we had ratified the Constitution. Article 5 was now an option, and he was warning against the use of it. And just to make things more clear, he even refers to the convention he's warning about would be triggered by the previous application of 2/3 of the state legislatures. Remember I said Article 5 requires 2/3 of the state legislatures applying for the convention, 34 states by today's numbers. If he's not talking about an Article 5 convention, can you think of any other kind of convention that's triggered by the application of 2/3 of the state legislatures? What else could he be talking about there? And the answer is there is none. This is clearly a warning against the dangers of an Article 5 convention, and his main concern is the present temper of America. At the end of 1798, in the end of 1788, he was concerned there was a lot of political discord going on. Are we any better today? Do we have a lot more unity politically among the people? Is this a good time, or should we be equally concerned about the present temper of America? And as I'll show later, there's a lot of concerns about the present temper and the present knowledge of America regarding constitutional history. This is clearly another false claim. Now, oftentimes, we point to solutions like Madison did in Federalist 46, nullification, that the states can stand up and refuse to help implement unconstitutional laws. Because of their number 2 claim that I illustrated, this is the only solution, Article 5 is the only solution we can use, they have to always discredit any other valid solutions. And so nullification, they'll point to, that violates the Supremacy Clause. What does the Supremacy Clause say? Article 6, Clause 2, it says, this Constitution, and the laws of the United States which shall be made in pursuance thereof shall be the supreme law of the land. What does in pursuance mean? In following. Laws that are made in following the Constitution are supreme. What does that imply about laws that are not in following the Constitution? Let me bring in an expert on that one. Here we have Alexander Hamilton in Federalist 33 telling us, acts of the federal government which are not pursuant to its constitutional powers are merely acts of usurpation That is theft of power, and will deserve to be treated as such. How do you treat an act of Congress that is unconstitutional? How do you treat that as an act of usurpation? By not recognizing it having authority. Here and many other places throughout the Federalist Papers, Madison and Hamilton both suggest the idea of states refusing to help implement unconstitutional laws, and even blocking them when necessary. So clearly, a proper understanding of the Supremacy Clause declares that only laws in following the Constitution are supreme. Nullification is only properly used when it's being used against unconstitutional law. And that is what our elected officials are swearing an oath of office to do. They're swearing an oath of office to uphold the Constitution. This is clearly a false claim. Article 6, Clause 3, requiring every elected official, state, local, federal, to swear an oath to uphold the Constitution, that matters most, upholding the Constitution, when the federal government is not. That's when it really means something. That is nullification. Therefore, I call the nullification is the Article 6 solution. There truly are other solutions the founders pointed to. On this topic, we have an article here talking about state governors admit the federal government needs state help with most federally funded programs. When we were looking at a government shutdown, the National Governors Association sent a panicked letter to Congress saying, we don't know which of these federal programs are being shut down and which ones aren't, and what we're supposed to be doing. Since you rely on us, and here's the key part, the federal government depends on states to get these things done, to implement their unconstitutional acts. We need your guidance on which ones you're shutting down. By doing so, they just admitted where the shutoff valve is, didn't they? The states have it in their hands to shut down a majority of the federal programs which are unconstitutional. And pressure from we the people to our state governors and our state legislators is what's needed for our states to stand up. Now, is this happening today? Absolutely. In fact, here's a recent article from the 10th Amendment Center which tracks these types of things. And so far in the year 2017, they declared we've seen already over 200 bills that would qualify as nullification bills being introduced in state legislatures all over the country. This is a growing movement. It has a long and successful history throughout our nation's history of states refusing to implement unconstitutional bad laws. This brings up what I would refer to as the ruby slipper concept. You all are familiar with Dorothy Gale, the Wizard of Oz, where throughout that story, she is following the yellow brick road trying to find the wizard because she believes he is her only solution to her problem of getting back to Kansas. What does she find? The wizard turns out to be a fraud. And she had the power all along. In the same way as the Nevada State Legislative Assembly discovered that their application for an Article 5 convention was a fraud, just like the wizard. And they already have the power all along. Our state legislators have already have the power to rein in the federal government, as do we the people. We don't need to change the Constitution. We have the power now. So going back to their three claims that I started off with, they claim that this was the purpose of the Article 5 Convention to rein in an out-of-control federal government. Clearly not true. The Article 5 Convention was for correcting errors in the Constitution, not for reining in an out-of-control government that simply won't obey the Constitution. They claim that this is the only solution. Again, that's false. The framers recommended many solutions to usurpation, but they did not include Article 5 as one of them. And finally, they claim it will be totally controlled by the states, and 1787 wasn't a runaway convention. Well, according to Madison, the 1787 convention exceeded the tenor of their commissions. There's no escaping that. A convention today can do the same. It's time for us to look to the founders' true solutions, not fall for these false claims of this Article 5 convention being the solution to our nation's problems. We already have the power. We don't need to change the Constitution. And as we'll demonstrate in Part 2, there's tremendous risks with the various amendment proposals that are being circulated now. So Part 2, Proposed Amendment Analysis. Justice Scalia gave a warning in May of 2015. He says a constitutional convention is a horrible idea. This is not a good century to write a constitution. What does he have against this century? What's his concern here? I think that's probably best illustrated by looking back to history when we were a very different people. In the early 1800s, this French philosopher and author, Alexis de Tocqueville, came to America to discover what made America great. What was our secret to our overnight success? He pointed to our miraculous Constitution as being definitely a backbone to it. But more specifically, he said that in America, every citizen is taught the history of his country and the leading features of its Constitution. It's extremely rare to find a man imperfectly acquainted with all these things, and a person wholly ignorant of them is sort of a phenomenon. Everybody understands our national history and our Constitution. Does that sound like today? Not at all. If I were to apply this to today, I'd have to reverse it and say today it's extremely rare to find a man who is vaguely acquainted with all these things. And a person wholly educated on them is sort of a phenomenon. What was our great strength in the early 1800s is our great weakness today. This is not a good century to be writing a constitution. I totally agree. Whether in whole or in part, even amending a constitution, you'll see, could cause tremendous concern and damage. I compare it to inviting a love poet who is an expert in matters of the heart to perform heart surgery. Is that a great idea? Very likely, rather than doing any help, they'll likely kill the patient in the process. In the same way, if we have people who are totally ignorant of what our Constitution already says, performing heart surgery to our Constitution, they're very likely to kill our Constitution in the process. The Convention of States organization has demonstrated this for us very nicely. They did us a great favor. In September of 2016, they held this historic simulation of an Article 5 convention, what we call the mock convention, where they invited delegates from all 50 states, mostly state legislators, to come together in colonial Williamsburg to pretend to role play through a Article 5 convention. In this convention, here are some of the details. Number one, this was by invitation only, and most were Convention of States bill sponsors in their home states. So a lot of their own people were the delegates. Number two, Convention of States paid all the expenses for everyone that attended. Next, the Convention of States wrote the rules for the convention, whereas in a real convention, the convention writes their own rules, decides their own ground rules from the beginning. Here's an interesting one. Convention of States leaders were on hand in the committees guiding the drafting of the amendments that came out of this convention. Just like a real convention will be, right? I doubt that. And since it was just a simulation, they had no real power and therefore no temptation to abuse such power. And in like manner, there weren't the myriad of lobbyists there trying to get their views inserted into the changes being made to the Constitution. The only lobbyist group that was there was Convention of States themselves, which were definitely on hand. In the end, we see that they had 137 delegates to this convention. I personally went through and researched every one of those delegates to determine what their political affiliation was, and I discovered that only 4 of the 137 were Democrats. There was one Republican turned libertarian, and all the rest were Republican or at least conservatives by strong standing. This is a very imbalanced convention. In fact, I would refer to this as a fantasy dream team for conservatives for a convention. Nothing like the real convention will be. We'll see far more moderates and liberals there than we will see true conservatives. But just the same, what came out of this imbalanced convention is very shocking. Let me show a few of the examples of what they came up with. They came up with a total of 6 amendment proposals. We'll start with this one, the lame duck amendment. Y'all know what a lame duck session of Congress is? After the election in November, prior to the next session of Congress, those who are not reelected, yet they are still in office in Congress, now have no incentive to listen to the will of their voters. They're on their way out. You've got nothing to do for them. This is the time when the politically unpopular bills are easiest to pass. Why? What is their motivation? Who are they listening to during lame duck session? If they don't need to listen to their voters anymore, the only other voice that really has much bearing on them are the lobbyists, the special interest groups. And they have a much greater time now of getting unpopular bills through Congress. This is a terrible idea. Typically, the lame duck session of Congress lasts for about 1 month, and if I were to make any changes to this situation, I would suggest we need to eliminate it. Maybe allowing a provision for times of emergency, like Congress needs to have a special session to discuss whether or not to declare war, if they were still doing that thing. But rather than eliminating the lame duck situation, this mock convention suggested that we should expand it. A little shocking. Extending the lame duck session for the House of Representatives to 2 years, and for the Senate, let's extend it to 6 years. Is that shocking? How did they get a massively conservative delegation to vote to extend the lame duck session, and it passed with a 70% majority? How did they sell them on that? It's very simple, actually. It's all about packaging. You don't call it a lame duck amendment. You call it term limits. Now give this an honest assessment for a moment. What do term limits do? Once someone is term limited in office, let's say I'm your US congressman and I'm just entering into my final term of 2 years, and I now have 2 years where I have no incentive to listen to the will of the people because I have no chance for re-election. I am now a lame duck congressman for my entire 2-year final term. Or if I'm in the Senate, that's 6 years. That is the same thing. In fact, our founding fathers, under the Articles of Confederation, they had term limits. And they recognized this to be a great error. When they formed the new Constitution, they explained this very thing. This is why we're eliminating term limits. Let's use some of their words specifically here. Alexander Hamilton says, "Nothing appears more plausible at first sight, nor more ill-founded upon close inspection than term limits. One ill effect of the exclusion would be a diminution, a reducing, of the inducements to good behavior." They no longer have to listen to the people, right? "Rather than when they were permitted to entertain a hope of obtaining, by meriting, a continuation in office. As long as they have a chance to be re-elected, they have an inducement to good behavior. We're getting rid of that with term limits." That's why he explained in Federal 72 why they had eliminated it from the Constitution. During the Constitutional Convention, when they're debating whether or not to keep term limits, Gouverneur Morris took the floor and explained to him why he felt we need to eliminate it. And this is the argument that won the day. Term limits tended to destroy the great motive to good behavior, the hope of being rewarded by reappointment. It was saying to him, "Make hay while the sun shines." Next, let's turn to John Adams, who gives also some great advice on this topic. "The people should be at liberty to choose the ablest and best men. Yet upon the present term limits supposition, the people voluntarily resign this right and shackle" who? They're shackling their own choice. Who do term limits limit? They limit the will of the people. The people should be at liberty to choose whomever they desire to elect to office. Term limits take away the choice from the people. And finally, Thomas Jefferson. "I know of no safe depository of the ultimate powers of society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take this power from them, but to inform their discretion by" what? Education. And his concluding line here is very key. He says, "This is the true corrective of abuses of constitutional power." What is he saying is the true corrective of abuses of constitutional power? You don't take the power of the vote away from the people through term limits. You educate them, inform their discretion by education. True constitutional solutions there. Another amendment proposal that came out of this mock convention, they called the Federal Legislative and Executive Jurisdiction Proposal Number 2. In this one, they want to give state legislatures the power to overturn federal law. Here's how it reads. "The legislatures of the states shall have the authority to abrogate," think of the word veto or overturn, "to abrogate any provision of federal law issued by Congress, the President, or the administrative agencies of the United States, whether in the form of a statute, decree, order, regulation, rule, opinion, decision, or other form." Let me ask you, where in the Constitution does it authorize the President or the administrative agencies to be creating federal law? It does not. In fact, This would expand federal power by overturning Article 1, Section 1, which declares only Congress has the power to declare, only Congress has the power to create law. If we were to pass this amendment, you are now giving tacit approval for the president and administrative agencies to legitimately create law anytime they wish, and as long as the states don't stand up to it, it is now legitimate constitutional law. We accidentally just expanded federal power. The next clause is also concerning. Section 2 says, such abrogation shall be effective when the legislatures of 3/5 of the states, or 30 states, approve a resolution declaring the same provision or provisions of federal law to be abrogated. What is that saying? It takes 30 states to overturn any federal law. If we had this amendment on the books in 2005, we would have lost the battle over the Real ID Act of 2005. What did happen? Without this amendment in place, 12 states stood up and said, we refuse to implement the Real ID Act. The Real ID Act was very unpopular. This is a national ID card with a national database of a lot of personal information that people were very leery of the federal government collecting on them. And so there was definitely a groundswell movement to oppose it. 12 states refused to implement it, and when the deadline came along for implementation, the federal government backed down, extended the deadline. Again and again and again, they've extended that deadline. Because as long as you have enough states standing up saying no, they know they cannot win that battle. Instead of that, this amendment proposal weakens state power by requiring 30 states to nullify. If this was on the books at that time, the 12 states standing up to the Real ID Act would have lost. The federal government would all they'd have to do is say, that's nice that you're opposing it, but until you have 30, you must comply. This is weakening the power of states to nullify unconstitutional federal law. I don't suppose that these errors in this amendment were intentional. Again, this is like love poets trying to do heart surgery. If they don't truly and deeply understand the Constitution as it now stands, unintentional errors are bound to happen. Now, often they'll make a defense that, yes, but we were only there for 3 days. We didn't really have enough time to properly vet these amendment proposals. And that's not exactly true, because these amendment proposals have been circulating for years prior to the mock convention. I've been writing articles and speaking out against these amendment proposals long before they were brought up in the mock convention. These are not new ideas, and despite my showing the flaws in them, they're still pushing them. So there's some concern there as well. By the way, this one also passed with a large majority. 86% thought this was a good idea. Now, on the topic of the Real ID Act, just for a quick side note, here's a great article from Cato saying, no, America, you don't need to comply with the Real ID Act. Every few years, you'll see the federal government push, starting the beginning of next year, citizens from the following states will no longer be able to fly on the airlines unless their state now starts to comply with the national ID card standards. The point of this article is, as long as those states continue to stand up saying no, the federal government does not have the political capital to push this issue. They would be pushing it through the TSA, probably one of the most politically unpopular federal agencies. And ultimately, what would happen if suddenly, half a dozen or more states are being blocked from flying on the airlines? Who's going to lose that battle? That'll be the TSA. The public opinion against TSA would soar, and they would be forced to reconsider or disband the TSA if they kept pushing the issue. That's the point of this article. Great article. We don't need to be conned into this. Now, there's another proposal that's being pushed constantly from several different angles, and that is a balanced budget amendment. Presently, at the time of filming this video, we have 28 states who have applications that are live, applying for an Article 5 convention for the purpose of a balanced budget amendment. And if we were to try to balance the budget today, under current numbers, we have roughly a $4 trillion annual budget, and the current revenue level is about $3.6 trillion. So we have a budgetary shortfall on average right around $400 billion. If we were to declare that the federal government must balance the budget, here's the effect of that. You're now declaring as long as they spend within the revenue, it is authorized by the Constitution. You're now making constitutional expenditures on anything as long as it's being met by the revenue. Now, of course, the federal government isn't likely to just trim back their spending to match revenue. They're far more likely to try to raise taxes to meet current levels of spending. We've accomplished nothing at that point other than an increase in taxes. And the big concern is this now constitutionally authorizes spending on anything, regardless of if it's authorized by the enumeration of powers or not. This replaces the constitutional limits on spending and jurisdiction, allowing the federal government to do anything they want as long as they've raised the revenue to pay for it. That doesn't help things, but there's a bigger concern here. These amendment applications include a loophole that in the absence of a national emergency, Congress would be required to balance the budget. When was the last time we had a national emergency? The answer is to check your watch right now, because it is right now. We're under roughly 30 declared national emergencies presently. And as this article demonstrates, from USA Today, special report, America's perpetual state of emergency. It points out that not only are we under roughly 30 simultaneous national emergency declarations, we have continually been under emergency state since 1979. Which begs the question, if we had passed this balanced budget amendment requirement back in the 80s when they almost were to the point of having enough states to do so, how many budgetary years since 1983, say, would they have been required to balance the budget because we were not under a national emergency? The answer, of course, is 0. There would not have been one moment that the balanced budget amendment requirement would have actually required a balanced budget. So not only are we authorizing Congress to spend on anything they want to, we're also not requiring them to balance the budget. And looking forward, if you add this incentive that as long as we're under a national emergency, Congress can keep spending all they want to, I guarantee we're going to stay under a national emergency indefinitely. This is an amendment proposal that will accomplish no good. There's no upside to it. On the other hand, what does the Constitution already require? Current federal spending around $4 trillion, revenue around 3.6. And if we were to rein in the federal government to what is actually authorized by the Constitution, you're looking at about 20% of our current spending levels, giving us a roughly $2.8 trillion surplus annually if we were to rein in the federal government back to what the Constitution actually authorizes. The solution here is enforce constitutional limits of power, and we'll get far more than a balanced budget. We'll have a surplus. Now, you remember I mentioned that this mock convention had a massive amount of moderates? No. 4 Democrats. Massive amount of conservatives and Republicans. What would a real convention look like? Which will largely be dominated by moderates and liberals. Even the more conservative states, I live in Montana, considered a conservative state. Ask any conservative legislator who your state legislators would select as a delegate to this convention. Would it be the conservatives or the more moderate and liberals? And they all agree they're going to be selecting moderates and liberals. That's what's going to dominate this convention. So what would that convention look like? Here's one idea. A former Justice of the Supreme Court, John Paul Stevens, suggests 5 words that can fix the Second Amendment. I didn't know it needed to be fixed, but he thinks so. He suggests that the Second Amendment should now read, a well-regulated militia being necessary to the security of the free state, the right of the people to keep and bear arms, when serving in the military or the militia, shall not be infringed. Which means that unless you're under active duty, you have no right to bear arms. That effectively repeals the Second Amendment by just adding 5 words to it. That is one angle, one suggestion that's being promoted right now. On a liberal blog that I was on recently, where they're also promoting an Article 5 convention, they're discussing this. One of the things they said is, yeah, we agree with this idea of having term limits on Congress, but you're going to have a major concession. We are not leaving the Constitutional Convention, no matter what the purpose it was called for, without also securing a campaign finance reform amendment and abolishing the Electoral College. It doesn't matter if we call this convention for a balanced budget amendment or whatever else, term limits. We're not leaving unless we get our way, is what they're telling us. Campaign finance reform amendment, this is one that's being supported by Wolf-PAC and George Soros' organizations, saying we need to overturn Citizens United Supreme Court ruling, make all elections publicly funded through taxpayer dollars, which makes government the gatekeeper of who qualifies for campaign funding. The other one, abolishing the Electoral College, should definitely be a big concern, especially to the smaller states. This would really allow New York and California to dominate the presidential elections, giving very little voice to the rest of the country. Both very dangerous ideas. You have to keep in mind, in 1787, there was the Great Compromise for the Constitution between the big states and the small states. The Great Compromise was the Senate will still represent every state equally, the House will represent based on population. What would be the Great Compromise if we held a convention today? Because we're not getting conservative-sounding amendments through without giving something to the liberal side as well. It's going to be a great compromise, and as I've demonstrated, the conservative amendments being proposed don't solve the problems. But in order to get those, we're going to have to give up some things to the other side as well. So, I frequently come to this. People finally, there's no way they can argue what I'm telling them. Yes, I admit, okay, the convention is a dangerous process, but we have to do something. And I hear many state legislators feeling like they're going to vote for it anyway, even though they see all the dangers and this could be a catastrophe. We have to do something. Again, wisdom from our founding fathers. Daniel Webster says, a strong conviction that something must be done is the parent of many bad measures. Don't be so desperate to do something that we do something foolish. Let us be wise in the action we take. Let's look to the founding fathers. They did give us many good solutions, powers that we already have to rein in the federal government. So part 3, the Constitution itself is the solution. So now we turn to my favorite quote from President James Garfield, who gives us a great perspective on the power we already have. He tells us, now more than ever before, the people are responsible for the character of their Congress. If that body be ignorant, reckless, and corrupt, it is because the people tolerate ignorance, recklessness, and corruption. If it be intelligent, brave, and pure, it is because the people demand these high qualities to represent them in the national legislature. Who is he saying is responsible for our out-of-control Congress? We the people. We the people have the power. If we demand these high qualities of Congress, they will reflect it. Again, that brings up this ruby slippers concept. We already have the power, don't we? Thomas Jefferson tells us, you may remember this quote, if we think the people are not enlightened enough to exercise their control, their power with wholesome discretion, the remedy is not to take that power from them, but to inform their discretion by education. This is one of the many times where they talk about true correctives of abuses of constitutional power. Educate the people. Samuel Adams warns us, neither the wisest constitution nor the wisest laws will secure the liberty and happiness of a people whose manners are universally corrupt. Changes to the Constitution won't solve it, will it? Thomas Jefferson again tells us, if a nation expects to be ignorant and free, it expects what never was and never will be. To me, this sums up the Article 5 Convention movement. Ignore the ignorance of the people. We're going to save the nation anyway. You cannot force liberty on a people who are ignorant of the principles of liberty. We cannot be ignorant and free. They're trying to accomplish the impossible. We must address the true root of the problem to solve anything. He also tells us, educate and inform the whole mass of the people. They are the only sure reliance for the preservation of our liberty. And the last quote in this series, this is not a founding father, but also a great quote of wisdom. Thomas Edison tells us, the strength of the Constitution lies in the will of the people to defend it. Why does Congress not follow the Constitution? As long as we, the people, don't know the rules, they don't have to follow the rules. It's that simple. When we understand and demand adherence to the Constitution, they will follow it. Another video that I created a number of years ago is called The Power of 500. This is a lesson that I learned early on in political activism, that if we were to pull together a team of 500 people working in concert in a coordinated fashion in any congressional district, that is enough voice to start turning that entire congressional district more toward the Constitution. We've demonstrated this in my home state with Montana, where our congressman a number of years ago, we started to really focus on holding him accountable to his oath of office. and his voting record began to improve dramatically. He went from following the Constitution about half the time to around 90 to 95% of the time. He was strictly following the Constitution. And he started to refer to me as his conscience, being the organizer of this movement, to hold him accountable. In a friendly way as well. We do have the power to hold them accountable if we turn to the power the Founding Fathers told us to use. So what we need to do, very simple three-step process here. Number one, we the people need to learn the Constitution. I'll recommend reading the Constitution, studying the Federalist Papers, and the John Birch Society has a video series called The Constitution is the Solution, which is designed to help you and your friends come together and learn the Constitution together. This is a great tool to help you build a team of people who understand the Constitution and to magnify your voice. By using this series, gather a group of 10 or 20 people in your home, learn the Constitution together, and then start speaking in favor of it. Speaking in favor of following its limits of power and so on. You'll be surprised how much you can magnify your voice in this process. The second step, which I request of you, please help us defend the Constitution from what I consider to be one of the greatest threats it's facing today, this Article 5 Convention. Let's not subject the Constitution to dangerous amendments. As Scalia said, this is not a good century to write a Constitution. We need to protect and preserve the Constitution. The John Birch Society has many materials that are available to help educate on the dangers of an Article 5 Convention. And finally, we need to hold them accountable, the action part of it here. Quote from Thomas Jefferson says, "In questions of power then, let no more be heard of confidence in man, but bind him down for mischief by the chains of the Constitution." My favorite tool for this process is produced by the New American Magazine, the Freedom Index. This is the voting records of U.S. House and Senate compared to the Constitution. This is how we got my congressman to start following the Constitution better. Start distributing this Freedom Index all throughout the congressional district. They start having to answer questions like, well, it says here that you voted for a certain unconstitutional action. I wanted to ask you where you felt you had the authority in the Constitution for this vote. They get asked those questions very often. They start changing the way they vote if enough people are asking them those types of things. This is a powerful tool for reining in Congress, both the House and the Senate. It's a very simple process. We need to become informed. We need to help others around us become informed. And working together, we already have the power to rein in the federal government. We don't need to risk changes to the Constitution. Please help us sustain and defend the Constitution. Thank you.